and welcome back to the channel. This is the House of Law. And in today's video, we will talk about something sad. And the topic is death. I know death makes some people uncomfortable. Yes, it is a difficult subject. All endings are sad. Otherwise, why do they have to end, right? But we will not talk about the emotional aspect. I'm not here to talk about the coping mechanisms with death. But instead, let's talk about the legal side of death, particularly about the properties of the deceased. Have you ever wondered where these properties go? Who will receive these properties? And also, what's the procedure for transferring ownership of these properties from the dead to the living? All these questions will be answered in this video. So let's begin. So what is succession in Philippine law? There are three provisions in the Civil Code which give us a nutshell of succession. And these are Article 774, 776, and 777 of the Civil Code. Article 774 defines succession as a mode of acquisition by virtue of which the property, rights, and obligations, to the extent of the value of the inheritance of a person, are transferred or transmitted through his death to another or others by virtue of a will or by operation of law. Article 776, on the other hand, states that the inheritance includes all the property, rights, and obligations of a person which are not extinguished by his death. And lastly, Article 777 provides that the rights to the succession are transmitted from the moment of death. So what do these provisions mean? Well, first, succession is only open at the time of death. So the expectant heirs cannot demand that property of a decedent be transferred to them while the decedent is alive. And also, because succession only opens upon or at the time of death, it is possible that there is no property to transfer at the time of death. Now, succession is a mode of acquiring ownership. It is like the other forms of acquisition of ownership, such as delivery, occupation, intellectual creation. So title is transferred from the deceased or from the dead to the living, and it is done through succession. Now, succession transfers property, rights, and obligations which are not extinguished by death, meaning those that are not personal to the deceased. So examples of rights that are not extinguished by death and are transmissible to the heirs are the right to collect debts, the right to receive separation pay, and the right to substitute a stockholder in a corporation. Meanwhile, examples of obligations that are not extinguished by death and are transmitted to the heirs are the obligation to pay an unpaid debt, obligation to execute a contract or deed, and the obligation to deliver property. Now, excepted to these rights and obligations are those which are, like what I said, personal to the deceased, such that no other person can perform it, okay? And thus, they are extinguished upon his death. So examples of these are the right to receive pension if the pension is conditioned upon his staying alive, and the obligation to perform a skill or talent, and also the obligation to be part of an association or a partnership. Okay, now I'm sure you have heard some new words. Okay, so let's define some of these terms or words. So when you hear deceased or decedent, we are referring to a person who died and whose succession is now open. When you hear heir, heir is a person who is legally entitled to the estate or a portion thereof. Now, what is an estate? Estate is like inheritance. It refers to the net properties and worth of the deceased or decedent. Lastly, last will and testament. So, last will and testament is a legal document that provides a person's final wishes and instructions regarding his properties and who shall receive them. So, how should the heirs deal with the estate? So, upon the death of the decedent, the heirs are deemed co-owners of the properties. until partition. As co-owners, they cannot sell, encumber, or alienate a specific property or portion thereof. Again, not until specific portions of the property are assigned to these heirs. Now, the heirs will receive only the net estate. The net estate is computed by deducting from the gross estate unpaid debts and obligations, obligations to the state, taxes, and all other expenses related to the settlement and partition of the property. Okay, now the heirs, however, are not liable for those obligations and debts that are more than the value of the estate. Thus, if the estate is not enough, the heirs do not assume personal liability or responsibility for these unpaid debts and obligations. In that case, it is fair to say that these unpaid debts and obligations are deemed extinguished. Now, lastly, the heirs are liable to pay estate tax before they can receive their rightful share in the estate. Estate tax is imposed on the right or privilege of transferring or transmitting property upon the death of the owner. Now, what are the two types? Well, actually, there are three types of succession. Now, the two major types are the testamentary succession and the legal or intestate succession. The third one, which is called the mixed succession, is just a combination of both. So, what is testamentary succession? Testamentary succession is that in which the deceased left a valid last will and testament. Now, the law provides for the requisites or formalities of a valid last will and testament. There are two types of last will testament. You have the notarial will and the holographic will. Legal intestate succession is that when the deceased died without a will or he died with a void will, thus it is as if he had no will, or that one which has subsequently lost its validity. Now, like what I said earlier, mixed is a combination of both testamentary and legal or intestate, meaning a portion of the property may be subject of a will, but the other portion was left out of the will. The rest would be subject to legal or intestate succession. Now, what are the types of heirs? There are two types. First are the compulsory heirs. Compulsory heirs are those for whom the law reserves a legitim. More of legitim later. And these compulsory heirs succeed to the decedent whether or not the decedent likes it. Okay, example, these are your legitimate and illegitimate children and of course the legal spouse. Now, voluntary or instituted heirs are those who are designated by the decedent in his will, okay, to receive his properties upon his death. Now, what is legitim? Legitim is that part of the testator's property which he cannot dispose of by will, because the law has reserved it for his compulsory heirs. Who these heirs are and what their respective shares are provided for by law. What are the ways to settle and partition the estate? So there are two ways. First, the judicial, and the second is the extrajudicial. So by judicial way, it is by filing a petition for judicial settlement of estate with a proper regional trial court. Now, judicial settlement is advisable in the following situations. First, when the decedent left a will, or he had unpaid debts and obligations, or when the heirs are in dispute. Okay, so when the settlement is contentious, okay, the way is judicial. Now, extrajudicial settlement is without going to court and securing letters of administration, provided that the following conditions are present. So, one, the decedent died without a will. Second, he did not have any debt or obligation at the time of his death. Third, the heirs are all of age, or if there are minor heirs, they are duly represented by their legal or judicial guardians. Fourth, it is made by a public instrument or by an affidavit. This public instrument or affidavit shall be filed with the proper register of deeds. The proper register of deeds is the register of deeds of the place where the decedent had his property. Also, aside from registration with the Register of Deeds, the extrajudicial settlement must also be published once a week for 3 consecutive weeks in a newspaper of general circulation. Okay, let's look at some sample problems. First, Domingo was the heir of Faustina, who died without issue and leaving a holographic will. Under the will, Domingo's share was 9,000 square meters out of the property of Faustina. Before the will could be probated, Domingo sold the property to Loriano. Is the sale valid? The answer is no. Why? Because while it's true that Domingo was designated in the will, that will has not yet been probated. In other words, it has not yet been received by the court and allowed by the court. For inheritance to pass to the heirs, first there must be a probate of the will, payment of the debts and obligations of the decedent, and of course the corresponding transfer of the property by order of the court, okay, from the decedent to the heir. In this case, Domingo preempted the procedure. Problem number 2. 5 years before he died of cancer, Edmundo was home cared, with a private nurse attending to his every needs and wants. When Edmundo died, he left a will. He left to the nurse 50% of his disposable assets. During the probate of the will, the children opposed the disposition. The nurse, however, claimed that the wish of the decedent should be honored and respected. Is the nurse entitled to inherit? What do you think? Sad though it may seem, but the law prohibits the nurse from receiving anything from a testator. Aside from the nurse, the persons who are also denied the right to receive any property from the decedent are physicians, priests, pastors, and all those who attended to the decedent prior to his death. Problem number 3. In her will, Agripina Valdez ordered that each of her surviving children will get 100,000 pesos from her bank accounts, except for Tomas, who will get 500,000. The other children opposed the disposition, claiming that they should share equally to the estate of their mother. Is the opposition valid? What do you think? Should the shares be equal among the children of Agripina Valdez? Well, the answer is no. Provided the will does not impair the legitimes of the heirs, then the testator can give to an heir, to let's say a favorite child, a share higher than the others. For as long as the minimum is met, then others can receive more than the minimum out of the generosity of the testator. That ends our video on the important points of succession. You see, when we prepare for death, it would be easy and smooth for everybody, not just for the deceased, but also to those who are left behind, meaning to say the family. I hope you learned something valuable in this video. For comments, questions, and suggestions, let me know by writing them in the comment section below. As always, thank you very much for watching, and I'll see you in the next video.